likely live with both intense sunshine and heavily regulated homeowner associations. You want to lower your energy bill, and solar or EV contractors promise a seamless installation, but homeowners frequently face board denials based on community aesthetics. The Florida legislature has legally stripped associations of their power to issue blanket bans on green energy. Under Florida Statutes 163.04 and 718.113, boards cannot stop you from installing solar panels or EV chargers. However, having the law on your side does not mean you can bypass the architectural review process. Attempting an installation without board approval can still result in fines. Winning against a stubborn board requires weaponizing the state's specific compliance metrics, permit shot clocks, and legal notices to force their hand. Mastering this bureaucratic checklist is the only way to convert your legal rights into physical property upgrades without risking financial penalties. For single-family homes, the Florida Solar Rights Act voids any HOA rule that prohibits solar installations. Since they cannot ban the panels, boards often try to control their location, demanding they be hidden on the back of the house out of public view. This diagram illustrates the state's 45-degree roof rule. An HOA can only dictate panel placement if the location faces south or falls within 45 degrees east or west. If your board insists on a shaded, north-facing roof, you can override them with a shade and efficiency report. If the data shows their preferred spot reduces system performance, their demand is illegal, and you can place panels where most effective. These same statutory protections cover other renewable devices through the state's clothesline loophole. If a board must allow solar panels, they also cannot stop you from installing solar pool heaters or solar water heaters. If you live in a multi-story condominium, however, the legal landscape changes. Florida's solar protections apply only within the boundaries of your specific unit. In the vast majority of Florida condos, the individual owner does not own the structural roof. The roof is a shared common element. Because you do not own that real estate, you cannot use solar access laws to claim a section of the roof for your personal panels. While single-family homeowners can use engineering data to defeat HOA aesthetic demands, condo owners must navigate property boundaries that generally exclude rooftop solar. While solar is restricted for condo owners, Florida's right to charge law prevents boards from blocking EV chargers in deeded or assigned parking spaces. This right comes with a financial trade-off. The homeowner must bear 100% of the installation, maintenance, and insurance costs. You cannot tap into shared garage power for a flat monthly fee. The law requires the line to be separately metered or use an embedded smart meter to track your exact kilowatt-hour usage. This timeline tracks two very strict 14-day countdown clocks, triggered the moment your application is approved. Within 14 days of approval, you must provide a certificate of insurance naming the Condo Association as an additional insured on your policy. On the second track, if the building's master insurance premium increases because of your charger, you have exactly 14 days to reimburse the board for that hike. Missing either of these deadlines gives the board immediate legal grounds to revoke your installation. The right to charge law opens the door for condo owners to drive EVs, but it requires precise administrative management to avoid losing the charger. Many boards attempt to defeat green energy projects through endless delays or by claiming applications were never received. House Bill 1203 now requires large HOAs to digitize and post all architectural rules and forms on a secure online portal. Accessing these digital rules prevents property managers from hiding guidelines or retroactively changing the standards to block your application. The state also addressed local government delays through the 5-day shot clock mandated by HB 683. Local building departments must review solar permits within 5 business days, or they are automatically approved. This prevents the HOA from claiming they are waiting on the city. If your board issues an illegal denial despite a compliant application, you should issue a formal statutory notice for pre-suit mediation. This notice should reference the state's fee-shifting provision. If a solar installation leads to litigation, the losing party pays the winner's attorney fees and costs. This fee-shifting provision provides definitive leverage. Property managers typically warn boards to back down rather than risk a 5-figure legal bill drawn from community reserves. There is one final legal tether to consider: successor liability when you sell the property. Florida Association guidelines require sellers to explicitly disclose any EV charger or solar system to potential buyers. Before the sale can close, the buyer must sign a legal covenant agreeing to take over all maintenance, repair, and insurance obligations. If the buyer refuses to sign, the seller is legally obligated to pay for the removal of the system and restore the property to its original condition before closing. This matrix evaluates the return on investment for these upgrades based on your housing type. Single-family solar provides a high return on investment. Owners should use efficiency reports and fee-shifting notices to secure approval. Condo solar is restricted by roof ownership rules. Condo EV charging is feasible, but requires strict adherence to the 14-day insurance and reimbursement timelines. Florida's green energy statutes grant you specific legal leverage. However, getting a system installed requires treating the project as a formal legal negotiation rather than a simple home improvement.